Hey, everybody. It's Tuesday, November 1st. And with us today, probate and divorce is what our topic is. And we have subject matter expert is Miss Tina Gage, and she's with Fidelity Title. So here we go. Tina, it's all yours.
All right. Thank you so much. I appreciate that.
We just got to do one thing here, so that'll go for us. And then that'll work now.
All right. Thank you very much. Okay. So yes, as Darwin mentioned, I'm Tina Gage with Fidelity National Title and representing Grand Oaks, of course. If you're like me, you came to work today because you did not win the Powerball last night. So it will be fun to look back at this because it was $1 billion, but nobody won that. So that's okay. We're all here. We'll all enjoy. You got all those people. Okay. We'll just all enjoy the class and each other's company. So let's start. Yes. So we're going to talk today about probate and divorce. All right. So not the most fun of topics, but it happens all too often with real estate, selling properties, and we should all be aware of what we need to do in those cases in terms of the title work. Obviously, probate is something that can have many, many layers, but we're talking today just about probate and how it reflects on selling a piece of property. So death and divorce. We will discuss what happens when a grantor dies and how the transfer of ownership should be completed. Also, we're going to talk about divorce and what a title company needs to review in order to remove the party that is not awarded the house. Of course, we're going to talk about some pitfalls too and unnecessary pitfalls that make it complicated for no apparent reason. So death and title, as my slide says, again, fun topic. But in the event someone passes away and they own property, they cannot sign a deed to convey to a new owner, correct? I think we all agree on that. And then, so if they are entitled to property alone or entitled with another person or persons as tenants in common, then probate will need to be completed and a decision made by the probate court to whom is awarded authority of that estate. That person is known as the personal representative. And then the written notice to all the heirs or any interested parties that they may have in the estate is called a letter of authority, or we like to use acronyms in the title world, so we'll call it the LOA. Anytime a judgment is entered into court, it doesn't matter which court, there is, of course, an appeal period. There's a 21-day appeal period, which gives the right to any parties to object to that decision of who is the personal representative for that estate. Title companies want to make sure that they are ensuring a transaction where there are no objections to any of the heirs or any parties in this particular court case.
So there's been a term that's been a executor of the estate. Is there a difference?
Executor of the estate could be the same person as the personal representative. Yeah. We'll look at that on the letters of authority to make sure that the same person is named there. Yep. All right. Oh, went too fast. Okay. How can we avoid probate? So there are reasons of how you're being vested that you can avoid probate. One way is how you're vested. Like I mentioned, it's termed joint tenants with full rights of survivorship. So if you have a piece of property and you're in title by yourself, so if Tina Gage, what's my name, owns a piece of property by myself, but I were to pass away, that property more than likely is going to have to go to probate because I was the only owner of that property. However, if I were to deed my husband onto the property with me, and we, with that deeding, because we are husband and wife, it automatically is vested in tenants in its entirety because we're married. So if I were to pass away, the property would be automatically awarded to my husband. And if he were to pass away, then the property would be automatically awarded to myself because we're husband and wife and we're tenants in the entirety. If the case you have single people on title, for my examples on the slide, it says father and mother deed to father, mother, and son. You just need to make sure the deed says joint tenants with full rights of survivorship. So if any one of those parties were to pass away during any of the time frame that they own the home, the two remaining parties would be awarded the property without it having to go to probate. Then the last, of course, person that would be remained on the property would be the one that would own the property as the sole survivor of the property. Also, a situation is single man deeds to single man and single woman. So my son, when he bought his property, they were single man and single woman. Well, when they get married, we of course are going to change the vesting to be husband and wife, so that then forms that tenancy of the entirety. So they don't have to have a joint tenants with full rights of survivorship. However, in the time period that they're owning their home as two single individuals, we made sure that the deed said joint tenants with full rights of survivorship. So it's not necessarily our decision collectively as a title company or you as real estate agents to decide how title should be held. It's really the consumer's decision when they buy the property. But you can, of course, bring that up to them because they might not be aware of the situation that they have to have joint tenants with full rights of survivorship if they're buying a property as a single person or single people. So that brings up a question. Yeah.
Yeah, a couple of questions. Should we as real estate agents give guidance on how they should take title?
So that is probably considered the practice of law. So we are not attorneys. We as a title company are not attorneys. You guys are not attorneys. So you can ask questions as to how they might like to take title. And you can, of course, refer them to the title company, us. We would be happy to explain the differences and what happens if someone were to pass away and with the property, and then they can make a collective decision on how they want title to be on their deed. Also, we would also tell them, if you have an attorney or a financial advisor or a CPA that you want to go ahead and ask that question to and get their professional opinion, we would recommend that as well.
Awesome. Now you may be hitting this, but a will and probate. If someone has a will that avoid probate?
So a will not necessarily avoid probate on the property, but it will enhance the decision of the deceased on who gets the property basically when they pass. So you'll be able to, let me fill in these slides. You'll be able to, without question, grant their wishes of the property.
And basically probate will essentially simply say this were the wishes, rubber stamp it.
So in most cases, yes, it could still be, the probate could still be contested by other heirs. But again, the will then would be submitted to the court to have them decide if the will is going to uphold the questioning from the heirs.
So then there's a question in regards to a trust, and we might be a little off subject.
Uh-oh.
Yeah, what happens in a trust? Are you protected?
So if the property is vested owner is a trust or an LLC, I mentioned that in here, then you are protected from probate. So you, in your trust, when your trust is created, it has initial trustees, and then it has successor trustees that are named in the trust if the trustees were to pass away. So then that will be handled in the trust document. All right, so let's move on. Letters of authority are issued by the court establishing the party to represent the estate. I think I mentioned that. They can be issued with or without restrictions. So if you happen to know of letters of authorities that are coming to you, before you send them even to Janet or to the title company, make sure they don't have restrictions on them. And some of the restrictions that can be listed on them state that they cannot sell a real estate property, which is obviously not going to help us in our situation. The letters of authority will be issued reflecting if the court requires an additional court order to sell the property. So there's lots of reasons why restrictions might be listed. And such might be listed because it's unclear how the assets are to be dispersed. For the example Darwin mentioned, maybe there isn't a will, and maybe there is 4 kids and they're all saying, I was supposed to get the property, and they all raised their hand. It also may be that there, again, isn't a will, and there'll be a dispute on the property or the funds from the sale. So there is not often court cases that arise, but they do happen. And of course, they do happen in scenarios that you're not expecting them to happen, but they do happen. If there's no restrictions shown, then the personal representative can go ahead and move forward with the sale without the court being involved. Letters of authority must still be in effect and not expired. I believe they are good for 1 year when they're issued. We will need the original letter of authority to record, to make sure that it's public notice that that person had the right to sign on behalf of the estate. We also may ask for a death certificate for the last person that has passed, just to make sure that their interest is also removed from the property.
Would it be an appropriate time to ask about the difference between letters of authority and if I have the power of attorney?
So a power of attorney, great question. Power of attorneys are actually, as soon as someone dies, their power of attorney is no longer valid because they are not alive. Power of attorneys are only used when you are alive. So if they were to pass and the power of attorney is to show up for somebody to sign on their behalf, if you think about it, you can't sign on their behalf because they can't sign on their behalf. So a power of attorney is voided at that point, at death. Thank you for the question. Okay, probate pitfalls. Consumers think that they should deed the property to themselves before or after probate. So we're going to say proceed with caution. And the reason we say that is because it's not always the best situation. It can really complicate things, and it's for a few different reasons. Title companies look at the quitclaim deed as self-serving and not with court approval. So again, I go back to the heirs. There could be 2 children and one child decides to deed the property to themselves because that's what mom said. Unfortunately, maybe the will or maybe the court said, no, the property is supposed to be deeded to the other heir in this case. And then now this starts a battle and more than likely another court case to try and figure that out. By deeding to themselves, they also take on the estate's tax liability unknowingly. So that's a big thing too. So if they're going to deed to themselves, they are now the seller on the property. If the property is over a certain dollar amount or even not their homestead, they have to understand that they're taking on all the tax liability for that sale. So if there's a large amount of proceeds, they're going to take on the capital gains for that. So we don't recommend doing that for those reasons. Also, the letter of authority has restrictions. If they don't have authority to deed the property, again, that complicates things, and we may have to go back to probate court to clear up that situation. If we have a question. So the question is, what document best protects the heirs in a tax situation? So it's going to be the letter of authority and who signs on behalf of the estate, because the estate is going to be taxed with the last person that died. Let's just say it was a single person on title. It's going to be taxed under their social security number or their tax ID number. That's where the tax liability is going to go. So the probate attorney or whoever is doing the probate will then disperse and take care of all that tax liability for them. If they don't, if the estate is not the seller, the tax liability will be on that person who did the deed to themselves. So they will take on 100% of that tax liability. They didn't answer that? Trust situation, it'll be the trust tax ID number. Yes. So, and I must say, trusts are a great way to hold property, but I also must say that make sure if you're meeting with your seller and they have a trust in place, make sure that they have a tax ID number for the trust as well as a bank account. Those 2 things are vital. For that reason, they need to take on that tax liability into the trust. The trust is there for financial purposes, so it's all set up for that, as well as the bank account. The bank account is usually the last piece that an attorney sets up for the trust. So hopefully the attorney has done all of those steps so that when the check is cut to the trust, that it goes into the trust, because that is who will receive the proceeds.
So to throw something out, previously we did a Hot Topic Tuesday with an attorney who addressed trusts. So what I would do is to encourage everyone to go back to that and look at that particular Hot Topic Tuesday. Bottom line is, somebody asked for guidance. send them to a real estate attorney
Absolutely.
and a CPA who can properly
Absolutely.
guide them on what they're really trying to accomplish.
Absolutely, absolutely. The trust is financial planning as well. So it's put in place for those reasons. If it's an LLC in title, it's going to be the same situation. The LLC is going to have a tax ID number as well as a bank account. And the checks, proceeds checks are going to be made to those entities because that's how they wanted to hold title. So that's how we'll follow through. Let's see, where were we? There could be a will that the title company doesn't have. So if there's a will and you think that we should benefit from that, then absolutely send it to us and we'll review it. Maybe it won't sway the decisions of the court, but it would be all in line with what the court's decision is with the letters of authority. In all these situations, there's just additional work and time that's needed to move forward with the sale. So it just causes unnecessary delay. And also, if there is a probate that has letters of authority with restrictions, it will need to be refiled with the court to remove those restrictions so that we can sell the property, or that you guys can sell the property and we can do the title work for it. So it is a simple refile, but it is necessary. All right. That's it for probate, unless anybody has any questions, and I'm open to any questions.
Right, you can take yourself off mute. You can take yourself off mute. That is the easiest way to jump in here. And I warned Tina in advance that you guys don't do that a whole lot. So the chat room's there also, but at this point, guys, any questions? There's nothing in the chat room.
Okay.
Yeah, that was earlier.
All right. Well, then, if you think of it, you can ask it coming forward, and I'm here still. So, how divorced are you? That's a question that gets a lot of chuckles, but it really makes a difference when the property is being sold, how divorced they really are. So the question is, how divorced are you? Is one party, or has one party moved out and they're just still discussing the divorce? Then they're still technically married in the eyes of title. Just filed the judgment of divorce, still married. Working through the assets with the attorneys, still married again. Filed and both parties have moved on with their lives, but have not been to court to sign any of the final paperwork. Maybe it's been years. They're still married, technically still married. And what that means, if you're still married, it's really just status quo. If you're still married, both people have to sign. The font says thumbs up, and it is just that. It is status quo. So the proceeds will be split in half, or to both parties on one check, and then they have to figure out what to do with them. But if you're still married, they could be going through the divorce, but it's just really status quo. So if the divorce is finalized, the judgment of divorce is issued. Again, we like acronyms, so the JOD. The title companies will follow the judgment of divorce and to what it says about the property split, or basically who gets it. Sometimes listed in the judgment of divorce. So we ask you for the judgment of divorce. We always badger Janet, can you get the judgment of divorce? Actually, she's so good. She actually probably already has it teed up to come to us. So, and the reasons that we ask for it, because there could be an attorney lien on or in the judgment of divorce. Sometimes attorneys ask for money up front to do the judgment, or sometimes they'll ask for a portion and then they'll put the rest on in terms of if the property sells, then they can pay it. So we have to make sure there's no attorney liens, because they will want to make sure that they get paid for it.
So when we say judgment of divorce, they get their papers, you on every page of it.
87 pages, if it's 87 pages. Yeah. Yep, absolutely. I know it. And if it's large, they can drop it off in your office. You guys can scan it to us, make a copy of it, or you can drop it off here in our office in the Rochester location, or any one of our offices, and we'll do the same thing. We can just make copies of it or scan it into ourselves if they don't have the ability to send that in, or they want to make sure that they keep the original. We're totally fine with that. And it isn't any, go ahead. Right. 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 So Janet makes a really valid point. The attorneys have every right to place a lien on the property or put it in the judgment of divorce. It is absolutely within their rights to do that. It is not something that is strange or out of the norm. And we do, as Janet mentioned, call to confirm that the attorneys have released all their rights or that they have been paid. And if they say they have, then we trust them. If they say they haven't, again, we still trust them with that information. Also is sometimes listed in the judgment of divorce, it says a deed will need to be recorded, removing the one party or the other party that wasn't awarded the property. And it also mentions the consideration of the shares and the settlement of the real estate. Basically, who gets how much money out of the sale of the real estate. And in times, it also says to record the judgment of divorce in lieu of a deed. And if that's what it says in the judgment of divorce, then that's what we have to do. Even though it is very personal, we do have to follow the rules of the judgment of divorce. The judgment of divorce will be our roadmap to how to proceed with the closing and then the disbursement of the proceeds.
Real quick to
Mhm.
add to that, this is 35 years of experience, that quite often in a divorce judgment, the judge will say, you must sign off and give him or her the property,
Mhm.
and yet they never refinanced the property. So the person who signed off on it is still responsible and it just creates another issue.
Right.
So beware of that. And I guess my key to that, order pre-title.
Yes, we love pre-title. And I know properties sell fast, but even just getting ahead of it a couple of days really helps in those types of situations.
And all of the title partners that we work with will do pre-title.
Mhm,
So
Very important to get in front of that. We'll go on to talk about divorce being finalized. If they're really divorced and it's signed by the judge and it's filed at the courthouse, then we can go ahead and move forward with only one person signing the closing statements and the deed after we review the judgment of divorce to figure out who that person is. We will determine who is awarded the property. If they ask for a quitclaim deed to be done, removing the ex-spouse from the property, there's a little asterisk there. I'll touch base on that in the next slide. The remaining person on title will have 100% 1099 liability if there's any on the property. And then we'll also pay out any amount owed to any attorneys or the ex-spouse on this settlement. So here's my asterisk. If we are asked to draft a quitclaim deed, or if your title company is asked to draft a quitclaim deed, if you're not using us, that's okay. Just remember, you could go back to the attorney to draft that quitclaim deed because drafting a quitclaim deed is the practice of law. However, if you it's been, as Darwin mentioned, maybe it's been 10 years since the divorce has been finalized and they're just now selling the property and paying off the other party, and that person is finally being deeded off of the property. We can, because we have a transaction open, draft that quitclaim deed to remove that other party. You'll notice on this slide, we just make sure that there's a little paragraph, let's call it, about that court case in the circuit courts, mentioning that it's going to remove or convey all the grantor's rights, title, and equitable interest, if any, because of that judgment of divorce. So that way, when that remaining person, that remaining spouse that has the property, let's say they're refinancing the property, they won't have to keep showing their judgment of divorce to say, okay, were you awarded the property this way? That person, the ex-spouse, has signed and removed all of their interest. So that deed, that statement should be on that quitclaim deed. So we would have that quitclaim deed signed either at closing or prior to closing to remove that ex-spouse. All right. And then the closing. So back to being married. If spouses are married, they're going to sign all the docs. We can split the proceeds to one spouse if we were given written notice from them both. But that spouse will have the entirety of the 1099 liability. So let's say they're going through the process of divorce. We're almost to the end, but the home sold so quickly in this market that they said, okay, let's just go ahead and sign. It's amicable. Nobody has any issues with that. But one spouse is going to be awarded the property. We'll make sure that we have written notice from the other spouse that that is acceptable. But that spouse will have all the 1099 liability. If they are divorced, the ex-spouse that needs to be removed signs the quitclaim deed. The remaining ex-spouse will sign all the docs, pay all of, if any of the liens on the property on the settlement statement, including any money owed to that spouse that deeded off. And then they'll have the 1099 liability and proceeds will be given to them pursuant to the judgment of divorce. All right. I am good. I am 30 minutes.
So
on
look
the
at
dot.
Nailed it.
I got one
So,
question
guys,
out there.
Yep, go ahead.
Whoever that is, yay,
Let's
thank
go.
you.
Joseph.
This is Joseph White. So we have, like you're saying, divorce. And they need a quick claim deed. Say the husband needs to do a quick claim deed to the wife or ex-wife.
Yes.
Does the title company do that, or does the husband, ex-husband need to get that done through an attorney?
So if you wanted, if they are selling the property and the title company has the title work opened, they know how they're vested and they have the legal description and the parcel number, they could, if you ask them to draft that deed. I know Fidelity would in those situations. If they're not ready to sell the property and we don't have title work open, but they know they're going to do it down the line, we would probably ask that their attorney draft that document because we don't know how they're vested in title yet. We don't have the legal description or the parcel number. And attorneys
Thank you very much.
are, yes, absolutely. And sometimes attorneys have that all part of the divorce. So they may already have that deed drafted as well as just part of the divorce that they're handling.
You know, we kind of talked about this beforehand. The aspect of no longer in the state of Michigan do we have dower rights that we need to work. What's with my voice today? Let me just do that.
It's 70 degrees
And
in
I'll
November.
sound like I'm still going through puberty. I'm good. Marital rights versus dower rights now.
Mhm.
It's common for one spouse, it's in their name, they get married and now there's a sale.
Mhm.
Is there anything that we need to be worried about regarding that spouse not on title, but they are married?
Well, yes, actually, there's a couple of things. First of all, the probate situation. If you have just one person on title, you always run the risk if that person passes away, going to probate. So if they are married and they are willing to, they can go see an attorney and have an attorney draft a deed to put the other spouse on title. If they purchase the property after 2016, I think it is, with our new owner's policies, that owner's policy will transfer to that additional spouse. So they will still have complete coverage. If they purchase the property prior to that, meaning an owner's policy is older than the 2016 version. Okay, so 1993, I'm told. So that will change then the owner's policy. So that's always something to take into consideration. Yes, dower is gone. But if you are husband and wife and one person is, yeah, probably the biggest thing is the probate to think of, is to make sure that ultimately, sadly, everybody passes away. So you
Yeah.
have to be ready for that.
So here would be the only part then that let's take death out of the equation.
Mhm.
My wife and I are married, but it's only in my name. We never put it in hers.
Right,
You know, we are going to sell our marital home.
right.
Does she need to sign anything at any point of the entire process?
If she's not entitled, she does not have to sign anything on the marital home. Correct.
Great, great stuff. So guys, is there any other questions? Because otherwise it's 12:30 in 15 seconds. If I don't see anything pop up, then here's what we say. Thank you, Tina, and thank
Absolutely.
you to our Fidelity guests and being with us, and Grand Oaks, a partner with us here in the Rochester office. Guys, you know, always the best way that we can say thank you is to give them the business. So she slowly drifts away and I'll go along with it. That's another Hot Topic Tuesday, guys. See you soon.